Thanks for your time, everyone. We appreciate this is a big topic and we're just going to skim over it all. So my name's Rachel Morris and I've got Lucy Donegan with me, and we're both solicitors in the healthcare litigation team within Hempsons. So we've got a bit of an agenda. So we've got an agenda. We're going to have a look at what a record is, which seems like going back to basics, but we're going to address the obvious question and look at what records are. We'll hopefully touch on why they're important, and we'll also consider their wider use and how healthcare records extend beyond the healthcare setting, and what might trigger disclosure and to whom. Before we move on to discuss these points, however, we've got a couple of contexts that we want to set out. So a bit of a disclaimer. As I've said, Lucy and I are litigators and we deal with clinical negligence claims. We do not have clinical backgrounds, so inevitably we're going to give an overview, but this will be skewed from our perspective and our experiences in the medical legal world. And our aim is to share insights about the records which we've encountered in practice. We are absolutely not telling you what to write. And it's simply our hope that if we enhance your awareness as to the wider scope in which the records can be used and the impact that they have, that might in turn inform you in deciding what to note down. We'll obviously be talking about the principles which apply across the healthcare sector. So it doesn't really matter whether you're a nurse, midwife, physio, dentist, the principles apply. And the other thing to note is that please don't think we're aiming to tell you to practice defensively. Anecdotally, I was recently told that advice given to a new member of staff at an organisation that might be represented or not was to not put things in the records if they were unsure, as that way they couldn't be challenged on it. It's incredibly frightening to think such advice is still being given, but it's also inaccurate. And I promise you that you can be challenged on the absence of an entry just as easily. I think the final thing to say before we start is that we know record keeping is viewed differently depending on your role. And while we understand there'll be a mix of people listening, I suspect most people on this call will be primarily focused on providing patient care. That record can often be viewed as an admin task to follow the patient care, whereas hopefully this webinar will show you that the record forms part of the care itself. And while we understand there are time and practicality constraints and nothing is ever perfect, we simply want to put you in the most informed position we can so that you make good notes which stand up to subsequent scrutiny. Pass on to Lucy about records.
So what is a health record? There's a temptation to consider the medical records to be the old style bundle of paper which hospitals or GPs and dentists. While we do still come across cases with the old Lloyd George style cards, we now the complex electronic system record in multiple places. And when systems don't speak to each other, there are increasing levels of risk that records can be missed or overlooked. We know that introducing new systems can be fraught with problems, and so good record keeping involves an element of being aware of how the systems work and where to add or look for information. We also understand that some trusts are in the process of converting from a paper-based style system to a fully electronic system, and that in some cases the old style paper records are in the process of being transferred onto the electronic system in batches. Therefore, when looking for information, it's important that both the paper record and electronic records are checked. So the UK statutory definition as set out within the Data Protection Act states that a health record means a record which A, consists of data concerning health, and B, has been made by or on behalf of a health professional in connection with the diagnosis, care or treatment of the individual to whom the data relates. There are other definitions out there. The GMC has its own guidance which suggests categories of documentation, but there is no catch-all list of what a health record is. We are assuming that everybody on this call is capable of applying some common sense, but the point we wish to make is that a health record can be wide-reaching. Gone back again. So on this slide, there are a list of documents which form part of the health record. The definition includes the obvious things, ranging from computer records and radiology to handwritten notes. And for anyone who also still uses them, the definition would also take into account a post-it note which may have been stuck onto a patient's record to draw attention to a particular result or update. An interesting case which we've had recently involved a midwife, and when she was interviewed, she mentioned that when she was dealing with observations for a patient who was in labour in the birthing pool, the iPad which was used for recording observations was on the other side of the room, and in any event she wasn't able to use it because her hands were wet. In this instance, she scribbled the patient's observations on a paper towel and then added the entries to the iPad afterwards. It's open to interpretation whether this paper towel forms part of the patient record or not. We will come on to discuss how this can impact record keeping requirements for making contemporaneous records. But the point we'd like to make is you can see the definition of a health record can encompass pretty much anything. In relation to outpatient appointments and what's often documented in relation to those, one of the things we come across a lot when dealing with claims is that whilst the patient record will include details of appointments which have been attended, and they will often note when a patient has failed to attend an appointment, the records don't always include the details of appointments which have been offered but subsequently rescheduled either by the patient or the department or clinic themselves. This is important because when you have a patient who needs to be seen, perhaps on an urgent basis or under the 2-week wait rule, and the patient is offered an appointment, but they don't accept that appointment or they call up to arrange it for the following week or month, the patient record often only records the original referral date and the date on which the patient attended. So when we're looking at those medical records in hindsight, we've got no evidence base to say why there was a wait for the appointment. And in cases relating to an alleged delay in diagnosis, this is clearly relevant when judging the standard of care provided. Just another quick example, we've also been involved in a case involving GPs where the patient has alleged a delayed diagnosis. This patient alleged that he was not recalled to receive important test results. The medical records did show multiple DNA'd appointments, but we're struggling to prove how the appointment was sent to that patient, as there was no information in the record as to whether it was arranged via a text message, a letter, or a telephone conversation. And then in this instance, the patient's denying all knowledge of these appointments.
So I'm going to start looking at some of the ones where the lines have started to blur, and we're just going to touch on a few specifics that have caused issues. We can't touch on everything. So the first one, MDTs, they often decide a patient's pathway, but it's important to reflect on how that's added to the individual's record. So do the patient notes identify those that were consulted and involved in the discussion? Do they set out any rationale or just the conclusion? So often in the medical notes, there's a one-liner to say, discussed at MDT. And the consequence is that if a claim is brought years later, we simply don't know who discussed what and why the decision was made. So our experts can be left guessing at why certain treatments were selected, and we have no idea who to approach for the factual evidence. I've put up a case reference there for anybody that's particularly interested. This was a case about the choice of treatment for a patient with cancer. And the reason it's been referenced is because in the defence, it suggested that the treatment was carefully considered in an MDT. So what happened was, as the case went on, the court ordered disclosure of the MDT minutes themselves. And the judgment, which was reported and included some pretty scathing criticisms, that MDT note itself was found to be negligent. There was no care plan, there was no clear selection process, no evidence that alternatives were considered, and there was no way to identify who was present at that MDT. And I'd say that that case isn't an isolated one. It's not unusual, and I've had cases personally where the MDT minutes either don't exist or years later no one can locate them. but if they form part of the patient journey, they must be in there. Moving on to the next bullet point, the COVID pandemic basically means that virtual consultations have increased. And we're now getting cases through where, for example, a whole GP discussion is available. Now, in this case, that can be helpful because it removes any dispute between the patient and the GP as to what was said. And the other knock-on effect is that in this particular case, it showed that the note was an accurate reflection of what was said between the two. So not only does that give the GP credibility in relation to that consultation, but it would lend credibility to the other notes made. The ready availability of photographs means that the uncertainty as to the appearance of a mole or an infected ulcer it is readily available. One of the things to bear in mind from a health professional perspective is that if you choose not to take a photo, and I'm sure it's not always practical, and there can be many good reasons not to take a photo, but the risk is that the patient will in any later claim produce their own photographic evidence. And this opens quite a complex process to prove the exact time or date and the exact presentation at the time the presentation was seen by the clinician, and that's not always straightforward. We've found generally that use of technology and easy communications can be a double-edged sword. So the conscientious caring therapist or clinician who happens to get along with those that they work with and pings a text or a WhatsApp message to a colleague whose shifts don't overlap. Is that good care? Well, some would say it is, but if that colleague needs the information, so does anyone else working with that patient. And so it should be in the notes which are accessible to everyone dealing with them. And I would caution against it. And be careful. We've come across a case where the NMC have been very critical of a nurse who took a call from a patient outside of work. It was outside of working hours, offered advice, but didn't note this up. It was still patient care, and there's a professional duty to ensure that information is available to everyone that comes across a patient. In this particular case, it involved psychiatry services. I'm sure you can all appreciate that in that context, an out-of-hours exchange can be determinative as to the next steps that someone else would take. Moving on to the penultimate bullet point, in a world where patient consent is paramount and everyone's an expert thanks to Google GP, information leaflets and web links are a crucial part of that consent journey. Consent is no longer a form that you fill in before a procedure. It's a process. So from a healthcare perspective, you need to take into account how fast things change, particularly online, and how after the event you're going to prove what was discussed. So for an example, in an obstetric claim about counselling for birth options, there's scope to go back 21 years or more. And in a case with a brain injured party, there may be absolutely no time limit. So a claim can be brought long after your personal practice generally, and the options available have changed. So you need to consider how you or anyone else treating a patient would know what you've discussed and what the patient's own knowledge base was when they made a decision about the treatment. There will be lots of grey areas, and I'm sure these will continue to emerge as technology advances. Mention some of these probably are a talk in their own right and well outside of today's remit. Reflective practice is probably one of those. I'm aware it causes lots of anxiety and there's quite a lot of case law on it. But the advice we can give in general terms is that the best way to avoid something becoming part of the patient record is to anonymise any learning. So I don't just mean take the name out, I mean making sure that the specifics are not so specific that that particular patient would be identifiable. And then it becomes your reflective practice, your learning, and not a patient record. So hopefully my next slide will be superfluous, I can't talk, won't be necessary because the importance of records and how they can influence a claim can be seen. But we put up this general assessment, actually from an article in the BMJ from 10 years ago. It's often cited, and the points it makes now are as relevant as they were then. The emphasis is added by us to show those two main reasons why you're all keeping records. So number one, it's applicable to all healthcare professionals to fulfill their professional obligations. And number two, and arguably the more important reason, is to ensure appropriate patient care. So does your note convey your plan, your thoughts and rationale, the next steps? Does it include any reservations? What's led you to the plan or might cause you to reflect and change it? Ultimately, if you're called off the ward or away from the surgery, or that patient is passed on for any reason, does the next healthcare professional need to do a full workup again? Or do they have everything they need to be able to check and, if appropriate, continue that process that's been put in place? Interestingly, that article that I've quoted goes on to suggest that despite their importance, medical records are often given a low priority. And it highlights that poor record keeping is a major factor in many litigation cases. I'm hoping I'm not telling you anything new, and that in the last 10 years, practice has changed. But one thing I can attest to is that the flip side of that is that good records really do facilitate the successful defence of cases. So ultimately, the importance of records is fundamentally linked to their use. It's all about patient care, but the wider uses of the records are where you start to think beyond patient care, because the records are ultimately evidence that can be used in a lot of circumstances. So they can exonerate you in a disciplinary, they can justify your actions in a claim, and they can allow an expert to confirm that you acted appropriately at an inquest. So always remember the many other circumstances in which records can be used beyond the healthcare setting. Never look at things in isolation. So the one entry in a patient record can be used by the coroner at inquest, it can be used by the coroner's expert, it can also be used by experts in a civil claim. It can be considered in a professional competency hearing, be that before the GMC, NMC, GDC, or any other hospital inquiry. In my personal view, a good investigation, whether that's a candor or a serious untoward incident, should usually consult with those involved as soon as possible after an incident. But so often we find that an internal investigation that's been done is disclosed to us having reached a conclusion, having set out some learning points, and it's based purely on an overview of the notes themselves. I think so often other healthcare professionals consider those records to be deemed determinative. In rare cases, and only with patients who choose to waive confidentiality, the patient record can be used to judge a healthcare professional in the media. And there are a number of blank spaces within this diagram on purpose, because we acknowledge that there are ever emerging ways that information can be used. And I fear that people on this webinar have probably encountered records being used in ways that we haven't and won't touch upon in this talk. So hopefully, having established their importance, Lucy's going to talk you through what makes a record good.
So as Rachel says, what makes a good record? There are numerous professional standards and guidance, some of which are listed on this slide. We'd refer you directly to the various sources of guidance which are relevant to your area of work, and I'm sure you'll also be aware of any regulatory duties which they impose. So the GMC Good Medical Practice states that a good record or a document, including clinical records, formally record your work. They must be clear, accurate, and legible. You should make records at the same time as the events you are recording or as soon as possible afterwards. Similarly, the NMC code states that you should attribute any entries you make in any paper or electronic records to yourself, making sure they are clearly written, dated and timed, and do not include unnecessary abbreviations, jargon, or speculation. It's probably helpful to remind ourselves at this stage not to include anything derogatory in the medical records. We know you often come across difficult patients and situations. For example, a patient may have been rude or angry, and this can have relevance to the medical note, but it needs to be approached sensitively. Before documenting, you should consider whether you'd want these to be read out in court, whether that be a coroner's court, civil court, or professional hearing. And if the answer is no, perhaps reconsider writing that. It may also be helpful to consider why you want to make the remark in the first instance, so that if you are questioned on your comments, you can explain the relevance of including this within your note. For example, in the instance where there's been an angry patient who's had an outburst, it would be appropriate to document what triggered that outburst, so that other healthcare professionals who come to care for the patient after yourself know that the patient may have a fear of a certain treatment or have certain biases. So let's try and unpick what defines a good record. A good record, it's very subjective, and it involves a huge exercise of clinical judgment and experience. The words on this slide have been taken from the standards shown on the previous slide, and they are commonly used words to describe a good record. So it's about making sure your record is understandable. Entries such as intermittent permanent headache, which is something we have seen within records previously, are clearly confusing and inaccurate. You must be clear what the patient has reported and what you are recording. It's also important that records are legible. Scribbling shorthand that only you understand is completely pointless, as anyone picking up the records after you will not understand what has occurred previously. You should also make it clear who is making the entry in the health records and whether they are the person who are actually making the decisions. If you're completing a ward round and you have a junior who is making the notes of what the consultant is saying, the health record needs to make it very clear who is making the decision and must also identify the parties involved and their roles. In our practice, we've come across a lot of trusts who have a policy where student nurses must be accompanied when assessing patients. We've had trial experience very recently where a judge was invited to make an adverse inference because the medical note, which had been documented by the student, didn't identify who the senior nurse accompanying the student was. The other side invited the judge to draw an adverse inference, being that the student nurse wasn't actually accompanied and was therefore in breach of the rules. It is important to ensure that everyone involved in the patient care is identified in the record. When making notes, it's also helpful to consider your position. If you're a locum or assigned to a department for a training module, consider how people will identify you years later when reviewing that record. Best practice is to provide your registration number on the note. In relation to making a contemporaneous note, timing is everything. If the note isn't contemporaneous, and we do understand that in some circumstances it's not always possible to make a contemporaneous note, the entry needs to be clear as to the time it relates to and when it's being added into the record. Looking back at the midwife we briefly discussed earlier with the paper towel, in that case, the midwife would need to have documented on the iPad that the observations had in fact been made earlier and in a different way. It's also worth remembering that electronic records do have metadata, and this can prove when records were changed. So if it doesn't add up, you may soon be facing an allegation of dishonesty, so it's always best to make it very clear when making the entry. Further, problems can be caused if something hasn't been documented at all. If something hasn't been documented within the record, but it's relied upon further down the line, this is hearsay and it can cause huge problems. It's important that all information must be documented at the time by the relevant person. We've come across a case recently where a nurse overheard the parent of a child saying something on the ward. This concern was communicated verbally from professional to professional, but no note of the original disclosure was ever made in the medical records. This verbal communication instigated the safeguarding process, which was followed by the chain of verbal communication only. And the safeguarding process ultimately resulted in the child being taken away from their parents temporarily. When the allegation was investigated by the court and the local authority after the event, it was impossible to identify which member of staff had heard the initial allegation, what had actually been said by the parent and when. As there was no record of this conversation, the case for parental distress had to be settled.
So what to include in your records? I'd love to be able to give you a quick checklist and say that it would then be safe, but I can't do that. And I repeat what I said at the beginning, we're not clinicians, and every case is unique, and ultimately it requires your clinical judgment. We do accept that most of the time you can't make a verbatim note of everything, and that's why that clinical judgment must be exercised as to what is important. In legal claims, there's often this assumption that if it's not been documented, it didn't happen. That's not necessarily true, but if it's not been documented, or if it's been documented differently, the risk of an adverse finding to fill in those gaps is much higher. So if you've got insufficiently detailed notes, or you've failed to note negatives, that can lead to adverse findings. So to give you a few examples, the common no red flags, it simply isn't enough, because how does another clinician or your solicitor in several years' time know what you understood the red flags to be? It can often be disputed as to whether that particular red flag was missed on a certain occasion. Describing an examination as normal doesn't give information as to what you were looking for or excluding. Risks discussed is absolutely not enough to show what those risks were for consent purposes. I'm sure everyone here is aware of a post-Montgomery world in which civil claims can't rely heavily on experts when dealing with consent. Ultimately, it's a matter of factual evidence between the clinicians and the patients. So where there's a dispute, a judge has to decide whether the information was sufficient based on the factual evidence. And ultimately, they're going to look to your notes first. Safety netting is another one that's just too vague to be of much use. And I recommend that in those circumstances, even if it's just one word and a tick, you expand on it as you're going through your process to note down that you haven't missed any of those safety net points or red flags. Another useful point on a practical level is that if you've taken into account some tests that you've ordered or some radiology, or conversely, they're not available at the time you make your decision, specify that. You wouldn't believe how often in a claim we're left trying to track down the exact timing of something and whether certain bloods or investigations were available to a clinician at the time a decision or entry was made. And all of that can be avoided if the notes state MRI reviewed, bloods checked. And the final point stems from the fact that it's really easy to transpose or mistype, especially numbers, which I think in medicine most of you will agree is important. Also letters. So you've got I've got a patient with peripheral arterial disease, I've had them with diabetic ulcers, and they progress ultimately to needing amputation. They've been treated for the left and the right at different times over the 12-year chronology. Having your left and your right mixed up or failing to specify which leg can make a really big difference to a defect in this case. I've even got personal experience as a patient, not a solicitor, of attending a wasted X-ray appointment because they wanted to do the wrong side. I've had to go back when the confusion's resolved. It can cause problems for patients, and it's always worth that few seconds to double check, and it can save time in the long term. But it's easy to make errors, so we're going to look at how to deal with them when they happen.
Yeah. So if you have made an error or discover an error in medical records, always follow the professional guidance. Don't just insert new notes or delete an entry. If it relates to a handwritten record, score the incorrect entry out with a single line, but don't completely obliterate it. The original text still needs to remain legible. If you've made any corrected entries into the health record, those corrected entries need to have a time, date, and signature stamp. And if you are adding additional notes to a record which you made earlier, for example, if you remember some information which you had omitted the first time round, when you add those additional notes, it needs to be clear when this additional note was added and why. The aim here is to avoid inferences of dishonesty. We all know it's easy to make errors when producing documentation, and you won't be criticised for correcting an entry unless it looks like you've tried to cover this up.
So I've got the fun topic of disclosure, which is probably a talk of itself, but looking at it from the medical records perspective. Historically, notes were seen as an aid memoir for the healthcare professional, but it's a long time now. It's since 1990 that there's been a right for patients to see their notes. It's probably one of the reasons you get less shorthand in notes, which is derogatory. But these can be sought simply out of idle curiosity. Generally, requests are sought in connection with a personal injury claim, but there can be other reasons. But ultimately, there are different acts or regulations that apply depending primarily on whether the patient's alive. And so you've got the different access to health records, subject access requests as to whether they're alive or not. But they can also be sought through a pre-action disclosure application or as part of the litigation process generally, in which case it would be governed by the civil procedure rules. And it's important to remind you that there's a continuing duty of disclosure throughout. So we're going to just provide a quick overview, but it's worth highlighting that the duty of disclosure can extend way beyond the medical record. So for example, it can include protocols, it can include your personal training records and those reflective statements we mentioned earlier. And the relevance for today's talk on records is to highlight that there simply are multiple circumstances in which there's a legal requirement to disclose the medical record outside the healthcare sphere. And at that point, the purpose of the record is wholly different, and it's a matter of evidence rather than patient care. So there will be situations where the medical record is sent to the patient themselves. It can be to their family, so their parents if they're a child, or children if they're deceased. It can go to the coroner, who has very wide powers and can ask for pretty much anything they think is relevant to their investigation. It can be seen by the police. Rather outside of my own area of expertise, I'm led to believe that providers often don't have to disclose records. There are, of course, limited circumstances where providers are compelled to provide information. But generally, it's open to the healthcare provider to voluntarily provide information if it's in the public interest. So these tests would often require you to have extra advice or knowledge. The GDC and the GMC have statutory powers which can compel disclosure, and it's not to the same standards as the NMC, which doesn't have those same powers. Solicitors and the courts have to follow the rules in the CPR as to whether the disclosure is necessary, proportionate, and appropriate. So there's many ways in which the record you made can come across the desk of someone else. And they go to experts, whether they're for coroners, regulatory bodies, or solicitors. And in my experience, a short, seemingly benign entry in the notes can be really scrutinised and take on a huge amount of significance. And I think anyone who's been through the litigation process will view their notes through a completely different lens. There's so much scope for what is or is not contained to be interpreted in different ways, but it can really be used to prove or refute a claim. On a practical level, I think the thing to be aware of is that there are lots of rules as to what should and shouldn't be disclosed, and there are timescales associated. For the most part, your organisation will have a protocol and often a specific department that will deal with requests for disclosure, and those handling the information will usually know what the entitlement and the obligations are. But if in doubt, always check with them. Ultimately, whatever route used to get the records, they become that important source of evidence. But it would be wrong to assume that it's straightforward. Give away my age a bit, but when I started in this field, hospital records were this huge set of paper records that had to be photocopied. Actually often looked like those copies had been thrown up in the air and rebundled without a care in the world. But as Lucy mentioned, we know now that they're increasingly electronic. Sadly, it doesn't always make for easier reading. We're correspondingly coming across an increasing number of examples where the records disclosed turn out not to be a complete set. And that actually puts the provider of those records in breach of their statutory duties. And it also opens them up to criticisms or adverse inferences. Incomplete records really do run the risk of an inaccurate conclusion on the part of a coroner or a judge. And people will be aware that that can be associated in turn with bad publicity if someone's committed the criminal offence of not disclosing something to a coroner when requested to. Unfortunately, as I've mentioned, that incomplete disclosure can happen for multiple reasons. Quite a lot of them are too technologically advanced for me to actually understand, but ultimately it seems that lots of electronic systems don't speak to each other. So whether they're used for reporting or storing records, the systems can have different functionalities, and they also might not speak to each other. So to put it into context, we dealt with a case years ago where the factual witness was really clear that a patient had refused a certain treatment. It was about a cannula being recited, and obviously trust protocol required it to be noted. And there was no such entry in the notes, at least the notes that the claimant solicitor had that they'd given to me. But this was a determined nurse who actually recalled this patient. So she went back to the ward, and we quickly established that there was a way of accessing daily entries made which only those on the ward seemed to know about. So when the records team had been asked for them, they didn't know about these extra steps to print out the records that sat behind the main system. The case was quickly abandoned, but had that information been available at the outset and printed, the case would probably never have been pursued, and that would have saved time for all involved. We had another case where the claimant solicitors had requested the notes via that subject access request. We actually got all the way to trial, and while preparing for trial in the week before, additional notes came to light, and this could absolutely have been fatal to the case. And non-compliance with that duty of disclosure would have led to criticism of the trust in open court. So we have an ongoing duty, and it's really important that people look in all the right places. So the main point we're trying to get across is that ultimately, if a request for records comes across your desk, check the entitlement, check the process, check if you need help to be able to locate all the notes. Are you being asked to consider the notes for third-party entries because there are rules about redacting them? Are you being asked to ensure they're not likely to cause harm to the patient? Ultimately, you just need to follow your organisation's structure, but please don't ignore the request, and please remember that there are statutory time limits for this.
So finally, in conclusion, good health records really do successfully defend cases. The medical records are the starting point in any claim or arguably any investigation. They are a contemporaneous record of events documented at the time in which those events occurred. Most people won't have a clear or reliable recall after an event. Studies have shown that patients only recall a percentage of things that were discussed in an appointment, even merely just hours after that appointment. How many people on this call could with certainty tell us exactly what happened in their consultations from last week? We don't think it'll be very many. As I say, we've successfully defended cases and had cases discontinued where the notes are clear. And as a final point, we'd just like to leave you with the quote on the slide, which has been taken from a recent trial in which we were able to successfully defend. The case related to a factual dispute, and ultimately the judge found in favour of the trust and found that the medical records were good and reliable evidence as to what had occurred, as these notes were accepted over the claimant's own evidence and the claimant's own recollection of events from 3 years previously.